no matter how you put it, there's a problem in Parliament that needs to be resolved. So different people have different views of what it is we are faced with, but there needs to be a way to resolve this. So what should be the way forward? I can afford 10 minutes each for each of my panelists on this issue. Okay, I'll start with Lawyer Pierre Dankwa again on the issue of what's transpiring in Parliament. What we understand is that the MPP MPs have actually triggered a recall of Parliament. They said there's some urgent business to be done. The NDC MPs say, when we come back, we'll sit at the same place. If you want to do business, go and see to where there are vacant seats. So there's certainly an issue. The Supreme Court still has that order. So we'll see how that plays out. But in the meantime, way forward, the discussion we're having. Lawyer?
For me, the issues happening in Parliament, like I told you earlier, is a crisis, is a constitutional crisis, clearly. Also, it reflects the dire degradation in regard to principle by people that we give our political powers to. And it reflects a very dangerous situation where, in my view, our democracy is being reduced to a kakistocracy. You understand? Because what's the foundation of all this issue? You know, I've termed this crisis as very needless. When you called me on good, it's a very needless crisis. And if our leaders, people who took an oath to uphold the law, would respect principle, we wouldn't be in this crisis in the first place. Because the issue is simple. The issue borders on whether or not certain 4 persons have left their parties. Okay. Because that's the issue. You know, Article 97 1G states clearly that if you leave the party on whose ticket you were elected into Parliament, if you leave that party, then you would vacate your seat. Indeed, the nature of that clause is even imperative. So first of all, it's a call on the MP themselves to vacate the seat. That's the first, because Article 97.1 is that a member shall vacate their seat, then the G, if they leave the political party on whose ticket they came. It's simple. It's very, very straightforward. Yes, and I hold the views of those who say that, see, you don't need to be a lawyer to understand this. Very straightforward. Now, I think also, even though it would be very difficult for me to understand, at least I would have understood if this was the first time this issue was coming up. Because this issue came up in 2020. And the Speaker took a certain act. The act for which the MPs are saying is unconstitutional. Then the question is, so when it happened in 2020, why didn't they speak up? Because they took an oath to defend the Constitution. So if in 2020 this issue came up and they kept quiet, then they've breached that oath. So those of them who were in Parliament at that time. You get. Now also, MPP, all this have showed clearly that they are now a threat to our democracy. You understand? It is not enough to say that you want to sack them. They are actually a threat to our democracy. Because see, what is the most important thing that this democracy seeks to achieve? This democracy seeks to achieve and guarantee the concept of the rule of law. That's the fundamental focus of our constitution, of this democracy. Because it is only the rule of law that can guarantee us our lives, our right to our lives. That can guarantee for us our right to our liberties. That can guarantee for us our right to pursue our individual happiness. Without the rule of law, there'll be chaos. Then the state of nature, which necessitated that social contract, you understand, would be returned. You understand? So if a political party that was formed to build that right culture that will sustain this democracy takes actions which are adverse to the rule of law, because when you're talking about the rule of law, you're talking about an abhorrence to arbitrariness. You understand clearly? You are talking about certainty of the law. You must be certain about what the law is. Now, their Constitution, Article 3, what does it say? you go and support an independent candidate, if you yourself you go independent, or if you support any candidate who's contesting against the candidate the MPP has sponsored, then you are deemed to have forfeited your membership. It's clear. Do you need to ask? The day I hoisted this yellow cap along with Alhaji Alhaji, I ceased to be a member of that party, and I'm not going back. I ceased to be a member of that party. When Alhaji Alhaji went independent, he ceased automatically to be a member of the MPP. He didn't need any letter to be written to him. Did I need any letter to be written to him? When I know him to Hosadoye, Solomon Usu, and all the members, the believers in the principles and philosophies of liberal democracy, who have not departed, but who felt that the MPP had departed from those principles, that right now they have been filled with familiar spirit. When we decided that we will stay where we are, so that I don't need to be called MPP. People change their names all the time. Doesn't mean that they've changed their character. You understand? So they are MPP by name, but it's not familiar spirit party. They don't believe in the rule of law, and so where the constitution says something clearly, they want to change their understanding of those Article 3. You understand? Now, if I had an argument that made me more convinced that they are a threat to national security, to the security of this country, that they have the right. In fact, it was the honorable MP for Toulon constituency, I think last week against what's it called, my own lecturer.
He didn't finish his SSS. How can you be referring to him?
But he said this, and
he said it.
He said it on news file. His party didn't right to distance themselves from the view he expressed. The party is actually acting in a manner in support of the principles he advanced on news file. That the party reserves the right to them that. Sorry, I was going to use which I know you'll be very angry with me if I mention you in any conversation concerning MPP. That let's say MPP member A, or in the case of Andre Siama, he said he was going independent. Then the party reserved the right to sack him. So that and they wrote a letter to that effect. But when these MPs decide to go independent, then the party reserves the right to say, okay, for you, we will not sack you. Now, so for such a party, do they reserve the right to even put themselves up to be considered for position for leadership in this country? I'm telling you, they are a threat to national security. And this bunch, our focus shouldn't just for them to lose 2024. Our focus should be to create a system where they cannot survive, where their likes cannot survive. Because you see, we cannot create a system where people who hate rule of law, who hate the only way our liberties can be protected, they are waging a war against democracy. Because immediately you promote acts of arbitrariness, immediately you support those actions, then you are waging a war against the rule of law. And when you are waging a war against the rule of law, then you cannot survive, or you should not survive as a political entity. Because then you don't understand, then you have an interest, other than the interest for which you should even become a political party. And that's why consistently they've delivered a governance, in spite of the oath their president took, the president of Ghana took, the president they sponsored. He's delivered a governance which is adverse to the oath he took, the oath to be faithful to Ghana, the oath to defend, protect, and defend the constitution of Ghana, the oath to dedicate himself to the well-being of every single Ghanaian. He has to be fair to all manner of Ghanaians. He's breached that oath. And the political party who touts their liberal democratic credentials say they are firm believers in the concept of the rule of law. They should be the ones starting the impeachment procedure against the president. They should be calling for the impeachment of the president, but they won't do that. And they are showing that character, that spirit, that familiar spirit in how they've handled this issue of the parliamentary crisis. They don't care about Ghana. So they don't care to do any act that will throw this stable constitution, democracy, into chaos. They don't call military people. What they're doing there. So supposing the wire in the military man's head twigged. It twigged. And he caught the gun. Mr. Speaker, get down. I've not taken over the country. What would they have done? Create a situation where you put this as system of governance at peril. But they are doing so because they don't regard principle. You need Solomon to define, to understand Article 97.1. And having done that, their majority leader, you understand, who ought to believe in the independence, in the equality, you understand, of parliament, who needs to understand why we need the concept of separation of powers to be upheld. Because I'm glad that I have my senior counsel here, I have Beatrice herself here, you understand, because we are running what we call a constitutional democracy, and it's premised on the principle of constitutionalism, which simply means limiting the powers of government. And one of the tools that they use to achieve that constitutionalism, beyond judicial review, beyond the concept of natural justice, one of the critical concepts is the separation of powers. You understand? Which simply possesses that, listen, we have 3 different powers of government. As to better achieve our liberties, we are not going to place all those powers into one hand. We are going to place different powers into different hands with the purpose of serving as checks and balance on each other. This issue come. What did the speaker do? All he did was to inform Parliament on a vacancy based on the Constitution. And you take this to the Supreme Court. You take this to the Supreme Court. So right now I'm sure in what's it called, 70s, when they lose less than 20, when they get less than 25%, and they will go to Supreme Court for interpretation. Whether if you get less than 25%, it means you've lost an election. So we shouldn't. There's a rule of law. It's not a rule by law. You understand? So listen. In my view, is simple. You see? So you threatened MPs. As I said, they are not a threat to national security. Because when all these things were happening, they had the effrontery, the temerity, the cockroach audacity to tell Ghanaians that if this majority-minority nonsense is not resolved in their favor, then we're going to abandon Parliament until... Did he not say that?
Yes.
Well, when he was saying, he forgot that the government had business to do. He forgot. And so right now that he thinks there's a stay, he wants to come back and do business. And so whose interest is he advancing? Those arguments they are making, that they care about the country, can it be legitimately made? Can it? So we have some few weeks to the elections. My view is that we have about 4 weeks. I think we need a massive reform in our constitution. And one of the massive reforms in the constitution is, first of all, so I have a problem with that clause. Because when Honorable Fuseni was an MP, he was not an MP for the NDC. He was an MP for every single member of his constituency. Because this democracy we are practicing, is also a representative one. Okay. So when the MP is my MP, don't at MP, he's an NDC MP, but he represents me too. You understand? So I think we need to reform that and remove that clause. Okay. The mere fact that you change your party shouldn't. But however, as things stands today, that's the position. Until there's a reform, that's the position. And those for MPs, they are no longer MPs for interest and purpose. So when they resume, should they resume Parliament? The NDC 136, they should conveniently, you understand? Conveniently, in solidarity with what the Constitution is saying, go and sit in the majority side. If they want, they shouldn't come. But Ghanaians rather know them. Come December 2024, you know there'll be 277 elections, one presidential and 276, they say. Now you know the caliber of your NPP people. They don't care about you. All they care about is how to secure their personal interests. So when we are voting, vote for Lanchamantin, vote for Lanchamantin, and vote against all these people, the majority, now the minority leader. These people who don't even have regard to principle, who don't have regard to a system that will protect your interests, your lives, vote against them and vote for people who care about Ghana. Vote for people who care about Ghana. And let us collectively as a people say no to any political party who has become a threat to national security. The MPP is a threat to national security. We must say no to them. Thank you.
Thank you. Thank you very much. Valos Man says Afenimaki is in court to test the ignorance, bias level or otherwise of the judges. When the Constitution says if you do so, forfeit your seat, is it talking about seat that they don't have yet? Which seat did the Constitution say you forfeit if you do something like that? Is it the seat that they are yet to contest for, which no one can tell if they will win or not? How do you vacate something you don't have? Let's stop. Good morning to you, man. There's Alhaji Alhaji. The only way to kick out this cruel SMP administration is to be vigilant on polling day. There's John Bauer. Is it Abeduni Robert who says, Senator, good morning. The MPP are implementing the Ejapade document, so those in the MPP party should not take this for granted because their future is at risk and because of tribal politics they are following a chain mafia. Beatrice.
I don't even know what to say. I wanted to concede my time to my senior because he's practically made all the points. I was wondering if he was even looking at my notes. I was mentioning all that. But I think what I want to say is that this issue should be a wake-up call when we talk about the NPP. It's not just because we are doing politics. And President Nanado behaves like an Arabian king and behaves as if when the father was dying, he called him and said, you know what, I will Ghana to you. You know, the MPP has a history of willing Ghana and properties of the state like Sir John did and in many instances. And so they have a certain nauseating sense of entitlement, which is not rooted in this concept of democracy. And sometimes when people say that Nanado did not really attend law school, even if you do not have evidence, you cannot also dispute some of these allegations because of his actions and inactions. Because I doubt, and there are 3 lawyers here, how somebody goes to law school, sits in the constitutional law class, writes a constitutional law exams and passes, and confronted with a situation, plunges all of us into a constitutional crisis. And has another leader in parliament, now the minority leader, Afenyo Markin, who is more concerned about how he is addressed and what position he occupies than the general welfare of the Ghanaian people. But I want to send a note of caution to the MPP and to say that the past is not the present. And the things they did in 2020, believing that the NDC was so civilized, the NDC would not push and make reckless statements because President Mahama has not made statements like there will be another Arab Spring, and now sebi obia wo mienu or die be die. And so some way somehow they are under a certain wrong impression. I think that if anybody knows the NDC better, it should be the MPP. What the capabilities of the NDC as a political party are. So I want to say that all these things we are having, or all these constitutional crises we are having, it's because Nanado behaves like somebody who was not elected. Like the country is for him. So we are all subject to his feelings. When he is happy, we have to be happy. When he's sad, everybody must suffer. Otherwise, one of the things that Parliament does a lot is consensus building. In fact, Parliament builds consensus so much that if you do not understand the workings of Parliament, sometimes they say that MPP and NDC are the same. In fact, the notion that the MPP and the NDC are the same came from the consensus that Parliament built. Because normally they would have agreed on the way. Even when you see them, sometimes you see us fighting. Honorable is on some page with me. You see us fighting our parliamentarians. Because even when they appear to be opposing the thing, by the time the thing has passed. So Parliament built consensus. So for us to get to this level, to the extent that we are fighting over chairs, and the MPP's concern is not you and I, but where they sit, should tell you the levels of lowness that these guys have introduced into public discourse and our governance structure. And you know, I want to say that the MPP are a group of dishonest people. That sometimes it appears the only time you can be honest and have a little bit of conscience is to leave them. Because in very recent time, when I watch TV and I listen to communicators from Alliance for Change, I wonder, so all of you were in the MPP. Lawyer here has made a very brilliant submission. And sometimes I wonder, on last Thursday, I was on the show with one other person called Rodalyn. And if you look at the questions, and she said, as for her, she's never been part of the MPP.
Yeah, she's been CPP.
Yes, she was CPP. But it appears that when you associate with the MPP, Ghana would not matter again. It is MPP, their pockets, and Ghana last. First of all, we were in this country when organized labor said they wanted to go on strike because of the rippling effect of the Galamsey. And the presidents who had this LI 2462, who was the one granting mining leases for people to go and mine in the forest bodies and destroy our water bodies, who could have unilaterally said that, you know what, the LI empowers me, so by even an executive fiat, I would not implement the provisions of the LI. Let's ban Galamsey activities in the forest and in water bodies. He could have just said that. Because he's not committed to fighting the Galamsey, said, you know what, don't go on strike. I will take the LI to Parliament for Parliament to revoke the LI. And they created the impression that they had to recall Parliament to come and, conduct this government business. So that the first priority of government business was the revocation of LI 2462. Then they said that, you know what, in this country, it matters not what our challenges are, whether you are unemployed, whether you can't pay your rent, whether you can't have a hospital, water, everything, our solution should be free SHS. And that the NDC is so opposed to the free SHS that they needed to bring a free SHS bill to solidify the free SHS and make sure that no government comes to abolish the free SHS. To the amazement and disappointment of Ghanaians. The memo, which is a petition and asking the Speaker to recall Parliament within 7 days, does not contain, as part of what the MPP considered urgent government business, a revocation of the LI 2462. It does not contain that. It does not contain the free SHS bill. It contains the interstate successions bill. A law, I want to see the memorandum to that act to see what even our challenges are currently with it. And the fact that the government wants to go for a $250 million additional loan. They need money for elections to come and share for you. So 6 weeks that we are going into an election, these are the things the government considers urgent government business, for which reason they have to recall Parliament. So what happened to the revocation of the LI? What happened with the much cherished protection of the free SHS. It tells you the levels of dishonesty, the hypocrites we are dealing with. The people have no regard. This in law we call negligence. It is a wanton disregard to our welfare as Ghanaians. They simply don't care. The president, people can be complaining that we have cholera outbreak, and he will charter the private jet. He wants to bath in the air. That is, and I mean, all we can do is to come and sit here and talk. He is not even watching the show. He is probably not even listening to any Ghanaian media. He's taking, I mean, some of the most expensive wine and Bel Air and having VSOP and doing a lot of things. They simply don't care. And I think that let nobody mislead you that the speaker has done something wrong. What they are trying to do is to cause disaffection for Mr. Speaker. Mr. Speaker, what happened last Tuesday has shown that he is a very wise person. He has practically had to save our democracy. These guys are a group of people who do not care. You see, they can't even see beyond their nose. This is the president that came to tell us there will be no haircut. And in less than 2 weeks, he could not even see that there will be a haircut. Okay. These guys must be rejected by every Ghanaian. The MPP must go back and restructure their party because we also need our democracy. And so they have to go back home and sit, have a sober reflection, and you and I have that duty to vote against them.
Thank you. Thank you very much. Ishak, I'll come to you shortly. Masola probably says, Akufo-Addo in 2016 told us to try him and Bawumia. We tried them, and they ended up leading us into the trying times we have found ourselves in today. As if that is not enough, they are again adding salt to our injuries, telling us to try Bawumia, who failed woefully as the chairman of the economic management team to become president. We are not going to do that. We'll kick them out of government by voting massively for John Dramani Mahama and the NDC to come back to power, to implement the 24-hour economy and many beneficial policies to get Ghana back on its feet. He sent that from Ayawa so East. And then Ambassador Sampiale says, so shameful that a country like Ghana is being held hostage as a result of who is majority and who is minority. The structure of parliament is anomalous because of the numbers. The gazetted results of the parliament is 137 for NDC and NPP. And it was wrong to have permanently added the independent MP to the NPP. To solve the trouble, the Speaker should simply call the MPP the government caucus or group and opposition caucus or group. Ishak.
Thank you, Sena. When there's a seeming constitutional crisis and in a panel, it appears you are the only non-lawyer, you have to be very careful. But I think that I am competent enough to take a bite on this topic. I am competent enough to take a bite on this topic, listening to Lawyer Apia Dankwa, because I think that before law there is common sense. And if you don't even have common sense, I'm not sure that you will be a good lawyer. And ever since the emergence of this unpalatable situation in Parliament, we have listened to all manner of lawyers, all manner of experts, governance experts speak on this matter. And I think that there has not been unanimity. The Article 97, 1 G and H, that is quite easy for anyone to understand, according to Councillor Apia Dankwa, including those who are not even lawyers like me, is being interpreted in a certain manner by people who are considered the best of lawyers. And I cringe when I listen to some of those people. Now, I've also listened to the reasons being given by the NPP for, most especially according to the Deputy Majority Chief Whip, now Deputy Minority Chief Whip, Habib, that the party affected by the decision of the MPs in question would have to write.
Now, amongst the four, there is an independent candidate. So who will write? If the NDC would have to write for their member of parliament for, where is that constituency? Memphis Central.
Central, yes.
And then the NPP would write for that of Suhum and then Gumwa West, Agona West,
Yeah.
because they are members of parliament on the ticket of those parties. Who would write to the speaker concerning Andrew Esiama? He is an independent candidate. So I see a certain level of absurdity there. They are not saying that anybody should come and notify the speaker. That provision simply says that once the speaker realizes that there is that vacancy as a result of a certain trend of conduct, he simply has to communicate same to the House, which the speaker did. And for me, I think that all of the decisions that the speaker have taken on this matter, up to the point of adjourning the House indefinitely, I think that deserves some big applause. I want to say that sometimes I ask myself what would have happened in this unique if parliament if we did not have somebody cast in the mold of Alban Bagwin as speaker, because his experience, his wisdom, his tact and all of that come into play at any point in time that there's a decision to be made. You understand? The decision to even adjourn the House indefinitely, in my opinion, would afford Parliament to look at how it will be able to resolve the matter before the House will reconvene. So I don't even understand the haste with which the minority, led by Afenyo Marken, is trying to recall Parliament. Because you claim, even before Tuesday's proceedings, that if you went to the House and the NDC caucus are taking over your seats, you were going to boycott, and you boycotted. It means the reason for boycotting was because of the sitting arrangements. I have heard the speaker say that those blaming him for what happened on the floor of the Parliament, their blame is misdirected, because they know that he is not responsible for sitting arrangements in Parliament. It is the work of the clerk to Parliament. And then this indicates that if you recall Parliament 10 times, that is where we would go and sit. So why is Afenyo Marken saying that they are recalling Parliament? Are they now prepared to sit where they are supposed to sit now as minority? Because from all indications, the speaker did nothing wrong. So I did not even understand why Afenyo Marken ran to court to interfere in the workings of Parliament, when Article 115 clearly insulates Parliament from any such control as that from the judiciary, like Afenyo Marken, a leader of the House, is seeking to do. They should not behave like crybabies. They should stand up. They are there to perform a certain function, especially that they are the caucus representing government, given the responsibility to prosecute government business on the floor of the House. That is clear dereliction of duty from the side of Afenyo Marken and the rest of the MPs in Parliament. For me, I don't want to think that this is something beyond being solved. The NPP must accept that the trajectory has changed. Something happened. It is apparent. Everybody sees it. It's not rocket science. I did not even want to cite the president said in 2020. Was it because it did not affect the numbers in Parliament that you were unperturbed, you were not bothered about it? And today the same principle has been applied. And they say that as for principle, it is principle. Principle is principle. It is wholly kept or wholly unkept. It cannot be partially kept or partially unkept. No. That constitutional provision speaks loudly even non-lawyers like me can understand it. They should accept it so that the 6 weeks left for the lifetime of this parliament can come to pass.
Thank you. Thank you, Ishak. I'll come to Alhaji to conclude for me. This is from George again, saying that the 3 arms of government operate under the supreme law of the state, which is the constitution. The problem of Afenyomakins is his group is that they equate the constitution to the Supreme Court. So when they shout rule of law, they mean Supreme Court. Very wrong. That's coming from George. There's Nana says Article 97.2, which is unfortunately ignored by most commentators in defense of Article 97.1, allows a member of parliament to retain his seat. Here it goes. 2. Notwithstanding paragraph G of clause 1 of this article, that is Article 97, a measure of parties that at the national level sanctioned by the party's constitution or membership of a coalition government, of which his original party forms part, shall not affect the status of any member of parliament. So therefore, clause 2 of Article 97 settles it all. Thus, a member of a parliament shall retain his seat only in the event of a measure and not in the circumstance of Article 97(1)G. That's coming from Nana. Dr. Percy says, in the face of the MPP's grand plan for mass disenfranchisement of voters in NDC strongholds for the digitalized theft of the December 2024, I should ask, who really guides the NDC on strategy? While the party abandoned its drive to get the roots of the machinery for electoral theft, the MPP-EC have put in place via forensic audit of the biometric register and ECIT system. And why is the NDC diverting energy and attention to a fruitless quest for majority in parliament? A majority that they meekly gave away in the December 2020 elections. Questions, my friend. That's Dr. David Percy. And then, okay, this Kojo Chumbuafu again. So now my regards to my brother lawyer, Apia Dankwa too. My brother, you never walk alone. You also pass your exams. This one is a different direction. It says, your pass mark in constitutional law wasn't changed from 12% to 72%. You know your classmate. You didn't graduate on Sunday and weren't dismissed from your alma mater for puffing toxic, noxious plumes of illegal black smoke, which has now been made legal by this Akufo-Addo government, if only you puff says smoke in industrial quantities. Alhaji.
Well, you see, in this matter, only exposes the hypocrisy of the MPP. And I couldn't have agreed more with Apia Dankwa. The actions and decisions of the MPP, considering the ruling of Speaker Bagbin in the last few days, exposes them as bigots. In 2020, precisely in November 2020, the MPP as a party invoked its constitution and wrote to Mr. Speaker, Speaker Marco Kwe, to declare the seat of Andrew Amwaku Esiama vacant. When Speaker Okwe abided by the petition and granted the relief sought by the MPP, I raised a concern and I spoke on the floor of the House that it was important for the Speaker to allow a debate on the floor to get the general feel of what Parliament as an institution thought about Article 97(1)G and H. They ignored me and pronounced. 4 years. The MPP saw absolutely nothing wrong with the decision until Speaker Bagbin did what Speaker Okwe did. They are now in law trying to tell us what is different in this situation. That's what they're trying to tell us. So I've heard Marco Okwe, my professor, he taught me politics in Ghana at the Department of Political Science, University of Ghana. He's not saying, oh, because the party did not petition Parliament, so Speaker's jurisdiction was not invoked. Ishak has answered it beautifully. So Ishak, never mind. You don't lack anything in law.
In fact, I'm in my second year.
You don't lack anything, you will pass. You might even get a prize. So he has answered it beautifully. So if MPP writes for the MPP MPs, NDC writes for the NDC MP, who writes for the independent? That's the absurdity. Thank you so very much for pointing out that level of absurdity. See, Apia Donko said something that, so about a week ago, I had a debate with a governance expert. And when I pointed that out to him, he conceded. When we had the first decision, and then there's this second decision, you were building the blocks of the rule of law as against Article 97, 1, G and H. So there had been an earlier decision and then a subsequent decision. So members of Parliament can now reasonably predict with a certain degree of accuracy the consequences of their actions. That's what the rule of law. So when you talked about predictability, the second leg of the principle of rule of law is certainty. Certainty. Now, what has MPP? So I agree with you again that they are a threat, a veritable threat, not only a veritable threat to our democracy. So when it suits them, they agree. When it doesn't suit them, they disagree. If you want the things that disturbs a democratic experiment is inconsistency. Consistency should be a virtue that we aspire to in our democratic experiment. So, Babon was right. He was right. He said he was not bound by the decision of Speaker Makokwe. He was right there too. But he came to the same decision Makokwe came to. Fantastic. No. And then Beatrice. You see, Beatrice, let me seek your permission to use you as an example. Beatrice is the second deputy spokesperson, the deputy spokesperson for His Excellency John Dramani Mahama. So as that's her capacity now. If Beatrice does anything that is inconsistent with that office, it's an office of John Dramani Mahama. If she does anything that is inconsistent with that office, and that will lead her to leave that office, it doesn't require John Mahama to write a letter. So, the fact that a member of parliament on the ticket of a political party is sponsored, that's what the Constitution says, a political party law, is sponsored by the party. That position, that office of a member of parliament is a position of the party. And when my party met in who I told all the members, they invited me to speak to members of parliament. I told them they were holding offices of the party. And that they had a duty to subject their personal views to the views of the party. So if you take a step that is inconsistent with your party's constitution, and that prescribes that if you take a certain step, you automatically lose your membership of the party. And if you are occupying an office of the party, tell me how that can be reconciled. It's totally incongruous. Totally incongruous. You cannot be a member of a party and continue to hold an office of the party. But we'll leave that to the Supreme Court to pronounce. But that leads me to the Supreme Court. Please, the Supreme Court should be a bastion, or the courts is a bastion for the protection of the fundamental rights and liberties of all of us. they should not allow themselves to be used as willing tools of manipulation. They should not. You see, we the people, that's the universal creed of democracies. We the people have elected unto ourselves a government created in whose name the powers of government are exercised. Have said, well, we are going to create 3 arms of government, and we are going to vest each government with certain with responsibilities. And that Montesquieu's theory has been proven to be valid. That if we vest power, all powers in one institution, it leads to tyranny. And so we are going to distribute the power, and we are going to create countervailing forces, or if you want, checks and balances, and ensure that no individual, no single institution will have power and dominance over all the other institutions. So if Parliament is working consistent with the Constitution and the mandate granted it by the Constitution and the standing orders, the Supreme Court has no business restraining it. No, you can't do that. It is only when Parliament strays out of its mandate, okay, in terms of the Constitution and the standing orders, that the Supreme Court can restrain Parliament, because they are doing something which is unconstitutional, and that is what Article 2 of the Constitution says. Somebody brings an action and says that what they are doing is unconstitutional, is inconsistent. But immediately they keep to the Constitution. How can you restrain it? You have no such power. The power you have, which is a power by extension, is the power in Article 130 to make final, authoritative, binding pronouncements on what the provisions of the Constitution mean. And so, in J.H. Mercer and the Attorney General, J.H. Mercer had gone to court to say that, oh, ministers of state cannot continue in office. So, the term of office of a minister is coterminous to the term of office of the president. And so when the president is re-elected, that is why he swears a new oath, because that term has come to an end. And in essence of the power vested in the president in Article 58, the president now appoints new members of his government. So those new members must also be what? Be vetted. The Supreme Court agreed and made a binding, final binding pronouncement on the interpretation of that provision, that after the term of office of a president, if the president wins, or the new ministers you will appoint will be subjected to vetting. Authoritative. It binds everybody. Everybody knows that that's the law now. But me and you, everybody, when we go to court, when we are speaking to our friends, we interpret the Constitution also. When we are interpreting Article 78, majority of ministers of state must come from Parliament. Now, do we need the Supreme Court to do that? We count the ministers and we take the numbers. So we don't. So we interpret the Constitution. Akufo did not go to the Supreme Court to ask if they say majority, what does it mean? No, so the Constitution, everybody interprets it. But where there is conflict, and where the interpretation, my interpretation and your interpretation will lead to a certain level of absurdity, then we go to the Supreme Court for it to make a final, that's what I said, final, binding, authoritative pronouncement. So what was the stay for? Then you find the reasons. I come to the reasons. First of all of us, 3 of us here are lawyer plus a law student. The Supreme Court has no speculative jurisdiction. No speculative. So they can't tell us that government business will be affected. What government business? And how will it be affected? The Supreme Court cannot speculate. You can't go to court to invoke the speculative jurisdiction because it has no speculative jurisdiction. Then you find the Supreme Court saying that government business will be affected. How did they come to that? I had a lecturer at the University of Ghana. Anytime you make such a distant statement, he asks you, what's the evidence? What's the evidence? That's the first one. Okay. I'm talking about the absurdity.
Yeah, you have to wrap up for me.
I'm going to wrap up so people to see how the state of execution was so absurd. The second one is that they said, oh, the people require representation. I agree with the Supreme Court. But the inconsistency of the Supreme Court is nauseating. I agree. Because Article 97(1)(c) is one of the grounds. Representation is one of the grounds that a member of parliament seat can be declared vacant. If that member of parliament absents himself or herself from parliament for 15 sitting days without the speaker's permission in writing and without reasonable explanation to the committee on privileges. So representation key. But I asked the Supreme Court to sitting here at your studio. So what animated their thinking when they issued an injunction to restrain Judge Kwesi from going to parliament? Because they did that. And they say fair hearing. They were not given fair hearing. They invoked the rules of natural justice, general rules. I say, Mr. Supreme Court, read Article 97, and you'll be left in no doubt that the framers of the Constitution knew where to require the rules of natural justice to be complied with, and where the rules of natural justice will not apply.
Okay.
So when the person dies, you don't wake him up and ask him, what killed you? To declare his seat vacant. When a person resigns under his hand, you don't invite that person to tell you what informed the resignation.
Okay.
But when the person absents himself, you must, the rules of natural justice is there in 97. So rules of interpretation. If the drafters of the Constitution had intended that the principles of natural justice will animate Article 97(1)(g) and H, they would have provided it.
Okay, Alhaji, thank